Esteemed professors, ladies and gentlemen, esteemed Professor Szilágyi, thank you very much for the invitation, and you made possible to present my paper here at the Central European Academy. The title of my presentation is a bit strange, maybe. The saga may continue. The saga means something that is having a very long time, something that is going on for a very long time. And you may ask me, okay, but the Romanian Constitutional Court can only have a 15 years experience with EU law. Yes, you're right, but we have to have in mind that before joining the European Union, there were a lot of efforts to modify, to amend the Romanian Constitution in order to permit the Romanian joining to the European Union. So actually I made a periodization of all these constitutional case law between 2003 and 2023, so 20 years. The saga may continue because, as we will see, we had a very tense relationship with the ECJ from 2018 till 2022. The first period in which the Romanian Constitutional Court tackled the problem of EU case law was actually in 2003, when in a certain decision the Constitutional Court established that it is okay to modify the Constitution in order to join the European Union, but made a certain statement in that decision, namely that the legal order of the EU is a separate one, but being separate and in hierarchical terms is between laws and constitution. So by this decision from 2003, delivered in the procedure for the amendment of constitution, the Romanian Constitutional Court emphasized expressly that the constitution cannot be, let's say, overruled by the EU regulation, EU directives, or by the EU treaties. Of course, the decision was criticized that time because we were speaking about two autonomous legal orders with no hierarchical relations. But we'll see what generated this decision from 2003 a bit later. And a second decision I want to point out is a decision from 2006, so a year before Romania joined the European Union, in which actually the court was put in the following situation. There was, in a certain legal norm, a discrimination on age criterion. A person wanted to become a lawyer, but the law said, yes, you can become a lawyer, but you have to have maximum 60 years, because you have to be, let's say, young in order to go before courts. And the Constitutional Court said, no, this is not good. This is against the equality principle from the Romanian Constitution, and tried to see what is the certain discrimination criteria that is not met. And the Constitution had no criterion on age discrimination. And then the court, the Constitutional Court, went to the ECJ case law, namely the Mangold decision, in which it found out that in the EU, the age criterion is a criteria of non-discrimination, and somehow applied it within the framework of the Romanian Constitution. So that's why I'm saying that somehow the court complemented the normative content of the Constitution. And as you've seen from my first slide, there were the 5 periods of time, and I skipped to the third period now, because in between 2008 and 2009 there was a period of, let's say, tackling certain things. It was a very strange period for the Romanian Constitutional Court, because it had no coherent approach towards EU law. But since 2009 till 2018, we can say that there was a Euro-friendly, and Bartosz corrected me not to say Euro-friendly, but European Union-friendly decisions. Yes, and I was talking to you, talking about Article 148, the second paragraph, that speaks about the Romanian accessions to the EU and what you have to do in order to reach this finality. And by a certain decision from 2015, the Constitutional Court identified in this article a clause for compliance of internal laws with the European Union acts. So it is the role of legislator, the Parliament, to enact such normative acts to be always in line with the European Union acts. In a decision from 2014, so 1 year before this decision, the Constitutional Court pointed out again that when it comes about the Constitution, you cannot give a carte blanche to the European Union acts and to apply them with priority, so to give primacy to the European Union acts toward Constitution. And that's why an initiative for the amendment of Constitution was rejected by the Constitutional Court, because that initiative said something like you have to give primacy of EU acts regardless that we are speaking about Constitution or any other acts. I want to talk about the norma interposta theory that was promoted by the Constitutional Court case law. Norma interposta is not an invention of the Romanian Constitutional Court. It's, let's say, an invention of the Italian Constitutional Court. So somehow we stealed it from the Italians. What does it mean precisely? You cannot perform a constitutional review towards a directive to say a law is unconstitutional because it is not in line with a certain directive or with a regulation or with a constituent treaty. But the court said, okay, I will give you two conditions in order to to gain this finality. The first condition is that certain law that is under review has to be sufficiently, the EU norm has to be sufficiently clear, precise, and unequivocal by itself, or its meaning must have been established in a clear, precise, and unambiguous manner by the ECJ. And the second condition is that the EU norm has to have a constitutional relevance. I want you to give you an example in order to not to remain these conditions only abstract conditions. After 2007, there were a lot of cases in Romania about these second-hand cars. So persons who are buying second-hand cars from outside Romania, they were levied by the Romanian authorities with a certain tax. It was a protective tax for the Romanians, not to have a lot of second-hand cars in our country. This law was challenged before the Constitutional Court, and the persons said it is unconstitutional because it goes against EU laws, EU regulations, EU treaty, so the liberty of goods movement in the European Union. And the Constitutional Court didn't want it to rule unconstitutional this law, and said, okay, the EU law that you are invoke, the EU treaty actually, has a very abstract, a very large content. So it is not sufficiently clear, precise in this respect. And the second condition is a subjective one. I will, as Constitutional Court, will point out when it has constitutional relevance. So this test is a very subjective one, and it leaves a margin of appreciation to the Constitutional Court in order to use the EU norm in the constitutional review. But even if these two conditions are met, not always the Constitutional Court will rule the norm is unconstitutional. And another example in this respect is the Common case. Everybody knows Common case, same-sex marriage in Belgium, and the American citizen wanted to establish in Romania. And according to the Romanian laws, if you are American, you can stay only, I think, 3 months in Romania, and then you have to go 6 months, and then you have to go back in the States, and another 6 months, and something like this. The Constitutional Court referred, it is the first and the sole case that was referred by preliminary reference by the Romanian Constitutional Court to the ECJ. And the ECJ said, you are not obliged to recognize such marriages, but you are obliged to give him the possibility to stay in Romania, because that person, Claiborne Hamilton, was married with Mr. Coman. And norma interposta, it means that the EU norm was very clear now after the ECJ interpreted it and had constitutional relevance, and the Romanian norm was unconstitutional because it didn't permit it to that certain American citizen to live in Romania. So basically, this is our test that we apply in regard with EU laws in constitutional review. Another question that appeared in our case law in this period was the national constitutional identity. Between 2009 and 2018, we didn't have decision in which we explain what is about this concept. But in 2012, in a national case, the court emphasized that the essence of the EU is the conferral of powers made by the member states in order to achieve their common objectives without ultimately undermining the national constitutional identity by that transfer of competencies. So it was a phrase. No one cared. Other decision repeated all the time this phrase, but it seemed that will remain as, you know, something that is repeated and not listened and not applied. But it happened in 2021, in the fourth period that I will analyze, that the court put it in front of us, this notion, in relation with the supremacy of the Constitution. So for the court, the idea of supremacy of Constitution was a question of national identity. Questionable, I say, because all the member states have this principle, the supremacy of the Constitution. And if it is a question of national identity, it means that actually it is a question of European identity. As I will show you, when we are speaking about constitutional identity, we have to speak about an identity substrate that can be opposed to the EU in a much finer one. It touches the very root of the state existence, peculiarities of wider general accepted principle, or the key, deep and sensitive elements of fundamental rights and freedoms. Why I am telling you this? Because I researched between Mr. Kuhn-Lennart's writings, and in 1990, in the American Journal of Comparative Law, he has a very interesting article and an interesting phrase. There is simply no nucleus of sovereignty that the member states can invoke as such against the community. Community, it was 1990. And that means that we have a pure European society in which national identities can be harmonized and to give rise to a European identity. So this is the conception of the European Court of Justice. And that's why, in order to oppose to such an idea, a question of national constitutional identity, you have to have a very specific one. And as you have seen at the previous slide, the ECJ even accepted such question of national constitutional identity in Boris Chilevitz, a case regarding the use of language in the education system. But the point is, who will establish that a certain question is of is a question of national constitutional identity, the ECJ or the constitutional courts. The ECJ says, you constitutional court have to make a preliminary reference, and I, the ECJ, via Article 4, I will tell you that it is about constitutional identity or not. The Constitutional Court says, no, no, I have to tell you what is national constitutional identity, and you have to accept it. So here we have this struggle between the two courts. As you know, it is for the Constitutional Court is the controlimity theory. Controlimit theory. The controlimit theory has three parts. So national constitutional identity, ultra vires competencies, and the level of protection of fundamental rights. When Romania joined the European Union, they made a condition for Romania. It is the Commission decision 1928/2006 and said, you have to be very good in judiciary, you have to combat corruption, etc., etc., etc. This decision meant to be applied in Romania for 3 years, from 2007 to 2010. And every year, the Commission had to set up some reports. The Commission set up a report in 2009, 10, etc. Working at the Constitutional Court, I was witness what were about these meetings with the Commission representatives. I witnessed 2 such meetings in which persons that had no legal background, experience, come to the Constitutional Court and ask us, what kind of decision have you delivered in this year? We delivered X, Y, Z decision. What are the status of them? The Parliament put in line the laws with the decisions. It is not the Constitutional Court competence to follow all this process, only when the case is referred to the Constitutional Court. So it was a kind of very strange dialogue. And in 2018, the Constitutional Court clearly writes in a decision that the decision of the European Commission on the cooperation and verification mechanism is mandatory for the state, and the reports are only recommendations. The ECJ, a certain certain Romanian court, referred a preliminary question to the ECJ in order to determine what is about with this Commission decision. The ECJ says it is mandatory for the Romanian state, namely for the Parliament, for the government, and for the courts, and these reports that were set up are a kind of soft law. In 2021, when we received this decision, the Constitutional Court entered into a failed dialogue with the ECJ, saying that, no, you were wrong. It cannot be applied, this decision, by the courts, because you have general questions there, general principles, to fight better against corruption, to not to permit corruption at the local authorities, etc. So it has no concrete normative value. And it was a clash between the Constitutional Court and the ECJ in this respect. And from this clash, we had the following problem. Romania in 2018 established a special unit of prosecutors with exclusive competence to investigate the criminal offenses committed by prosecutors and judges, so ratione personae. Before that, it was ratione materiae. That means that the National Anti-Corruption Directorate was competent to perform the investigation in this respect. And the ECJ pointed out that because of the cooperation and verification mechanism, you cannot set up such kind of prosecutorial unit because it seems that you are not strengthening the fight against corruption, but you makes it very weak. The Constitutional Court went and said, no, it is only ratione personae, and that unit is very good. Actually, in this quarrel, we have to see the facts. Because all these, that unit was unfunctional. So in 4 or 5 years, when it had to function, they had almost no cases with judges and prosecutors. So in 2022, the unit was eliminated from the legal norms and appeared a kind of ratione materiae and plus ratione personae, some special prosecutors designated from the investigative units in order to investigate such anti-corruption questions. But what I want to emphasize here at the cooperation and verification mechanism that between 2011 and 2012, the Constitutional Court see this mechanism as a kind of norm of reference, and I find 2 decisions in which actually some legal national norms were ruled unconstitutional because they were against this decision. And between 2018 and 22, the court says no, it cannot be the decision 2926/28 per 2006 cannot be used in constitutional review. So the Constitutional Court was not very constant in this respect. The CVM was the basis in which the European Court of Justice told to the Romanian counterparts, to the Romanian Constitutional Court, a question about the primacy of the EU. So this primacy of the EU must be interpreted as precluding legislation of a member state having constitutional status as interpreted by a constitutional court, according to which a lower court is not permitted to disapply of its own motion a national provision falling within the scope of decision 928. This decision of the ECJ somehow overruled that decision from 2003 of the Romanian Constitutional Court. So for the ECJ, it doesn't matter that we are talking about constitution or we are talking about Constitutional Court decisions. The primacy of the EU law means primacy towards all normative acts. Actually, in the Romanian constitutional system, there is a kind of debate between the notion of primacy and priority of application, because primacy, you know, it means hierarchy. It's more correct priority of application. The Romanian constitution is talking about priority of application. In 2021, I was speaking about this Romanian Constitutional Court decision. It is 390 per 2021. I call it failed dialogue because maybe it was better for the Romanian Constitutional Court to make a preliminary reference. It didn't do that, the Constitutional Court didn't make this preliminary reference, and that's why somehow it's questionable this decision. In this decision, the court said in another recital, if I establish you that a certain national provision is constitutional in relation with the integration clause, it means that no other court can apply EU law directly and no other court can challenge my interpretation. And of course, the next step was that a court made a preliminary reference to the ECJ, and the ECJ said, no, you're wrong, because every court can apply the priority of application of the EU law, even if the Constitutional Court said that it is in line with the integration clause. Another problem in this failed dialogue. Between 2016 and 2019, we had a set of 5 decisions. I will not try to explain you all these decisions because it should be complicated, but I will tell you the result of these decisions. Of course, I have to have a small information of background. In Romania, the investigation, so the prosecutorial investigation, went on with the help of the secret services. So there were protocols between prosecutors and secret services, and you know the secret services were taping and helped the prosecutors. The Constitutional Court says such kind of things are unconstitutional. The evidences that were obtained had to be eliminated from the files. If you have to be eliminated, that means absolute nullity. And the last two cases regarded the composition of the Supreme Court, and because the Supreme Court was not composed according to the law, the whole judicial process had to be taken again. So the case went to the ECJ, because a certain court, it was the Supreme Court of Romania, applied at the ECJ with a preliminary question. And the ECJ, in that case, indicated in my slide, says, if it is a systemic risk of impunity, you can put aside all the Constitutional Court decisions and you have to apply, I don't know what. You have to apply directly, I think, Article 325. That means the financial protection of the European Union interests, plus some text concerning anti-corruption measures. So, another case. The principle of the primacy of the EU law must be interpreted as precluding legislation of a member state having constitutional status as interpreted by the Constitutional Court of that member state, according to which a lower court is not permitted to disapply by its own motion a national provision. So the ECJ explained it in another case more precisely for the Constitutional Court, that a lower court can disapply all Constitutional Court decisions. We have to have in mind that after these decisions, around 75% of the courts applied the Romanian Constitutional Court decisions, and it was pretty interesting for the Constitutional Court. And finally, I want to give you another example, a more recent example, a decision of the ECJ delivered in July this year. The problem was the following. There were two decisions in 2018 of the Romanian Constitutional Court that ruled unconstitutional the statute of limitation. In Romanian law, the statute of limitation is substantive criminal institution, and it means that you may apply it retroactively if it is a more lenient law, lex meteor. The Supreme Court said, yes, it is lex meteor, so you can apply it even if the statute of limitation, the period of limitation, was interrupted before 2018, so retrospectively. But the ECJ say no. Because it is a systemic risk of impunity, you can apply those two Constitutional Court decisions only beginning with 2018 and somehow put aside the Supreme Court decision in which the Supreme Court said you can apply it retrospectively too. So I want to discuss with you, and maybe in our discussion session, about this concept, systemic risk of impunity. We will find this concept in, I think, 6th decision of the ECJ concerning Romania. Can a judge establish that there is a systemic risk of impunity? It is not a kind of probatio diabolica for that certain judge. What does this mean? How can he evaluate this systemic risk of impunity? I told you at the beginning that decision 148 from 2003, and after 18 years, the Constitutional Court applied again that decision, saying that EU law cannot prevail to Constitution. But of course, immediately after this decision came another decision of the ECJ saying that no, it can prevail over the Constitution too. So basically, this was my presentation. It was a very tensioned dialogue between 2018 and 2022. with very specific national subjects. Both actors, I think, had made mistakes. The Constitutional Court, because it thought that it can resolve certain things at national level, and the ECJ, because it was a case in which it pronounced against Romania 5 cases in which failed to have a dialogue with the Constitutional Court too. So it is the classic example when two jurisdictions are functioning by their own rules without having, let's say, a breach between them. And I recall your attention to a Russian painter, Ilya Repin. And Ilya Repin has paintings about the Zaporozhian Cossacks that writes a letter to the Ottoman Sultan. And they were writing rude words in that letter. I think it was the same here. The two jurisdictions written down everything they wanted to write against the other legal order, and that's why it was a failed dialogue. We hope that it was a useful failed dialogue in order not to happen again such a failed dialogue in the future. Thank you.